Congratulations on getting ready to buy your home. I just want to go with you over what you will be signing. Some of these forms you will not be signing, but one of them will be for sure will be the purchase contract and the agency. And I know I am talking to you real estate language. So if there is any questions, make sure you just write them in a piece of paper and we can go over um, either over the phone or when we see each other again. I just want to make sure you do understand what you will be signing once we find the house that you are looking for, and I will be with you all the step um, of the transaction. So this first page is really like your checklist. It's like the bullet points of all the paperwork that you will be signing on the purchase contract. So I'm gonna go over this last one at the very end. So let's start with page one. Page one, it's gonna have your name, it's gonna have the seller's name. Make sure when I send you all the paperwork, even though I check, sometimes I have errors. So just make sure your name is spelled correctly. And then on this section right here, and I want to make sure also before I keep moving forward, there is this little prints right here. That is important. It's just letting you know that everything will be spelled on the contract, but if you need tax advice, legal advice, that you contact your attorney or your tax advisor or any professional on any concerns that you might have. Remember, I'm a real estate professional. I'm here to give you all the resources, but I cannot give you legal or tax advice. So on this area, we are going to put the address of the property. And these numbers, I'm going to pick from the assessor number. I'm going to get it from the Maricopa County. Those are important information because that is the legal description of the property. And the legal description, all of this is information that I have access to the Maricopa County to make sure we have the right property. The county goes by the legal description and the assessor's number more than the address. Then we have on line 10, what is going to be the offer that you want to give to the seller for their home. And then on this line, I'm going to put the earnest money, and that money depends on what kind of loan you have. It can be 3.5%, 10%. And then on this line, it's going to be what is going to be the down. I'm sorry, let me go back. The earnest money is the money that we deposit in good faith to the seller to let them know that you are serious about their home. In this market, I suggest the more money you give, the more strong your offer it is. Right now in this market, I will say a minimum of $3,000. It will be a good amount, all the way to $5,000, $6,000 for the earnest money. The line 12 is going to be your down payment. That is going to be down payment that you're going to be giving for your loan. If it's a conventional loan, 3%, 5%, 10%, 15%, or 20%, depending on what you're doing. If it's FHA, will be 3.5%. And in here, I'm going to put what will be your estimated loan amount. This number is not on a stone, and this number is not on a stone. Sometimes things changes, and an adjustment needs to be done. But it's an estimated number of your loan. The final loan amount is going to be given by your loan officer. In here, I'm going to put in here how you're going to give the earnest money. The earnest money is going to go into the title company. If you have a personal check, that is fine. title is going to send a runner to your home, work, or place and pick up that check. If you prefer to do a wire, you can do a wire. Other will be maybe you don't have checks and you don't want to wire the money, and maybe a cashier check, it's more convenient. Now, it's a cashier check is it's not a money order. It's a check that you're going to have from your bank institution where you have your account. The down payment, you're not going to need to give it until we are about to close. And as things develop, your loan officer will be telling you how that's going to be, when you're going to need to give it to the title company again. The earnest money will be deposited into an escrow company. That will be the title company. You will have an escrow officer. And we must send with this offer your pre-qualification, or if you are buying cash, you need to give proof of funds to the buyer. So that's part of the offer here. In here, we're saying when we are offering to do a close of escrow, if you're doing a loan, normally it takes 30 to 45 days. In this market, I'm trying to do 30 days or less, but I always have a conversation with your loan officer about that to see if it's safe to give that number. Now, I want you to please make sure to always give room when you are planning on to moving, because sometimes things happens and your close gets delayed. The goal, I always work with your loan officer to make sure that is not the case, but sometimes there are things that get out of control, and we have to move the close of escrow sometimes a week, sometimes just a day. So I want you to keep that in mind. I don't want you to have a U-Haul in front of the house thinking you're getting the house on the day we have in the contract, and then something happened and we cannot record that day, and now you don't have plan B. I want to make sure that you give yourself time. If for some reason, and this is one of the cases that is saying, Nikki, for some reason, the title could not record the title to your name the day of the closing, they can do that the next business day. Now in here it says that you as the buyer are responsible to make sure the escrow company gets the earnest money and any down payment. Again, your down payment is not given until the last week when you're about to close. Now, if for some reason you don't give the closing, your down payment or the money that you need for close, then the seller is gonna give us what we call a cure notice, and your earnest money can be released to the seller. Now, the cure notice, it's a document that is issued when somebody is breaching the contract. And in this case, if you are not giving the funds for you to close, that is a breach of contract. The document gives you 3 days to remediate that, give title, your down payment, and then, or if the lender is late and has not wired the money, also can cause for a cure notice. That's why it's so important, the loan officer that you're working with. I'm always on top of doing follow-ups, but when it comes to your loan, things are out of my control, and all I can do is ask the right questions and make sure they are doing what is necessary. So Make sure if they ask you for any documents that you give it to the lender so nothing is delayed. So you have 3 days. The cure notice give you 3 days to get, if the loan officer has not sent the wire to the title company, it's giving 3 extra days. At 3 days, if the seller doesn't want to give us any extension, the seller has the right to cancel the contract and forfeit your earnest money. All the money needs to be on dollars, and you will be able to take possession of the property until the day the property is recorded on your name. And also, you will be receiving, sometimes you will not have all the keys of the house because the contract only requires to give the existing keys. So if the seller doesn't have a key for a lock or something like that, you are not going to get that. We have on line 36 to 38, we have other addendums that we use to accompany the purchase contract. And it's only if it applies. For example, if the house has solar lease or a solar system, we need an addendum for that. If the house is in a short sale, if the house is in association, or if you have a contingency, let's say you have a house to sell and you are going to do a contingency to close based on the sale of your property. Line 39 to 54. That's a list of what conveys with the property. Anything that is attached to the property should stay. The refrigerator does not convey unless it's attached to the wall, and that will be a sub-zero refrigerator type of appliance. The stove conveys. That's something that will stay, but the refrigerator is not. The washer and dryer is not. Those are things that are negotiable depending on the property, the market, conditions of the market. Right now, there is not a lot to negotiate for you as a buyer. But sometimes they're willing to leave those items, and then if they're willing to leave those items, I just add them in there to make sure you can benefit from it. If there is an above ground spa or a hot tub, that's also not considered attached. So that is something that if the seller is willing to leave it, then we put in here that it's going to convey with the property. Or if you really, really want it, that's something we can ask for. Again, we need to be within reason in this market. Since it's very competitive, you will be competing with other offers. If there is only other personal property that you would like the seller to leave, then that goes into line 61 and 62. If for some reason, line 62 and 64 is just saying that any additional property that is included with the property will not have any monetary value. It will be free and clear of all liens and encumbrances. And the reason why they put this language in the contract is because loan officers want this language for the loan when they see that the seller is giving you the refrigerator, the washer, the dryer, or the above ground spa, or if they're going to be leaving furniture. This section number 2 talks about financing. Your pre-qualification needs to be included with your offer. So that's why it's so important that by the time we go look for houses, you are already pre-qualified and ready to go. Your contract has a contingency for your loan to happen. So if for some reason um, you have conditions for the loan to happen, then we need to definitely let all the parties know, including title company. And this is so important to keep everybody on top of everything in case we need an addendum. The sellers start preparing for that. Um, if for some reason your loan get denied, your earnest money goes back to you if everything is done correctly. You do have what is called an unfulfilled loan contingency. What this means is if you, for some reason, cannot close because you do not have the money for the down payment anymore, then that is not contingent. It's not a loan contingency. It's unfulfilled loan contingency because you were not responsible on giving the money. If you are failing to close because you didn't like the interest rate, that's also not a reason for you to be able to cancel the contract without losing your earnest money. Once we are under contract after 10 days, your loan officer needs to issue what is called a loan status update. We call it LSU. And that is going to say what the loan officer has done for your loan, what stage the loan is, and the seller can ask for an updated one at any time in point. This form needs to be signed by your loan officer and also needs to be signed from you. So when the time comes, I'm on top of these tablines and I will be asking your loan officer for one if he has not sent me one when it's needed, and then I will send it over to you for signatures. This over here says that you will have to finish your loan application, which at this stage, by the time you are going to see houses, you are already done with this part. You will be, once you get under contract, your loan officer is going to be in touch with the title company because they want to know what their title fees are. So they will be sending you a loan estimate. We call it good faith estimate. And then these numbers are a little inflated because the loan officer wants to make sure that by the time you're close, the numbers are equal or less than what your loan officer told you and not more than they told you. Line 97, we are looking at this, and in here we're going to put it, what type of loan are you using? Are you using a conventional loan, FHA, BA, USDA? If you're making an assumption in your case, you probably are not doing or seller carryback. The most common are conventional loan, FHA. BA is if you have served our country, then that's one of the benefits our veterans get. All expenses that will be happening because of your loan are your responsibility unless that has been negotiated in the contract. In a more normal market or in a buyer market, normally on section 100 and 102, we ask the seller to help you with what we call concessions. And when you get a loan, you have what is called closing costs. Depending on the type of the loan you're using, depending on the purchase price, it can be $5,000 to $10,000 for closing costs. In your case, it's going to be around $5,000-$6,000, unless you are using a down payment assistant. But sometimes the sellers help with these expenses. Unfortunately, we are in a market when that is not possible. It is very challenging. And I'm not going to say it's impossible, but right now I'm not seeing any seller saying, yes, I'm going to agree to pay for your closing costs when they have 10 to 30 offers on the table, and everybody's trying to do their best to be able to buy the home. If there is any changes on your loan, we need to notify the seller immediately in the title company. Sometimes there has been cases where the buyer was using an FHA loan and now has to go conventional because something changed on the credit, or it is better for the buyer to do it this way. It is okay to do it as long as it's not going to affect the seller. So let's say you need to change your loan from FHA to conventional. We let the seller know, and we tell them this is gonna be okay because it's not changing anything for you. It's not changing when can we close. If we are now looking at that might change, then that can be a challenge. Because if the seller is not happy because you change something on your loan, then now we are looking at we're going to close later, and that will affect the seller, and that will be a breach of contract. Appraisal. Appraisal is normally paid by you. Sometimes when it's not a seller's market, we can negotiate for the seller to pay for it. In this case, you will be paying for it. It would not be applied to concessions, because in this market right now we will try not to ask for it unless you really, really have to. In this section right here, line 115 to 115 to 119, this is where the title company name is going to be. If you have a title company you prefer, just let me know. Maybe you have a family member, maybe you had an experience if you bought a house before and you want to use this title company. But if not, I have a couple companies that I have worked multiple times with, and I know that they will be taking care of you. So I'm sorry, my mouse is acting up. So section 3B to 3C, line 120 to 132, is just saying that you need to decide how you are going to obtain title. Title is going to give you options. They cannot advise you how to do it, but normally they will tell you what is the most common to obtain title. They will be sending you paperwork for you to fill up. If you have questions, contact the title company. Title documents are not my expertise, and definitely I don't know. I cannot also give you any advice on how you should acquire title. If you are married, then you need to do it one where, if somebody pass away, the other party is going to get the property without having to go to probate. And you can ask title about that, and they will tell you. Title is going to be issuing what is called a title commitment and a title insurance. The title commitment is going to be paid by the seller. That is by law, unless we negotiate something where you pay for it when we want to make an effort to win an offer. And the title insurance, title insurance is what the seller is going to be paying. Now, I don't want you to get confused on this one, because there will be two title insurance. One, the seller pays for you to have a clear title without any liens on the property. And the other one is title insurance for your lender. that you will be paying for, and that's what is those fees are included on your closing costs. The title commitment, it's gonna be a document title, is gonna give us within 5 days or 7 days of being on escrow, and they're just gonna do a report on if the seller has any liens, how much the seller still has to pay on the property, if taxes have been paid, if there is any easements on the property. That's important. All this information is going to be there. You get a copy, I get a copy. If there is something that gives a red flag, I always ask questions to see, how if there is anything we should be concerned about. But most of the times, it's very simple, very standard. The major things that you want to know is where the easement, every property has an easement, and you want to know where the easement to the city really runs in your property. So if you have plans to do a pool, do construction, or something like that, you know what it is. Most of the times, it's very standard. Most of the times, those easements run on the very back end of the property or the size of the property where your wall is. But in so many rare cases, it can be randomly in the middle of the backyard. That's when maybe it's important for you. I have had a case and the homeowner didn't really care. That easement was right in the middle of the patio on the property, which if they ever wanted to do a pool, they would not be able to do so. Line 123 and 142 is basically what I explained before. What escrow title your escrow officer is going to be doing in regard to information on the title. Taxes are going to be prorated here on in Arizona. We don't pay taxes in advance. We pay them in arrears. So the seller most likely is going to owe taxes when they transfer the title to you. What is going to happen is title is going to prorate those taxes. So they're going to charge the seller until the day the title gets transferred into your name, and they're going to give you a credit to you. And then they're going to charge you to pay late to have that into your escrow account and to be paid. And the same is going to happen with the home, with the HOA fees. If there is any irrigation fees, this happens more in older properties where there is irrigation fees paid to the city. Sometimes there are assessment liens. This very rarely happens, but let's say the city that you're buying the house has an assessment lien. This happened a few years back in Buckeye, and it was about water. So every homeowner needed to pay by certain date $5,000 for that task, for that assessment lien, and it was prorated. It's very rare for this to happen, but it's there, and sometimes we see it. But once you get these reports from title, you have 5 days to review. If there is anything that you disagree to it, you can cancel the contract and get your earnest money back. Let's say they discover there is an assessment lien in the property, and you don't really want to be responsible for that, or that is going to put you outside your monthly payment, your budget that you want to be. That's considered part of what you can cancel and get your earnest money back. Once you get under contract, we're going to section 4. Once you get under contract, you will be receiving something. I will be in the 3 days after your offer accepted. Normally, the seller will be giving us something that is called the seller property disclosure statement. We call it the SPADS. This is a questionnaire the seller fills up, and it has questions that might be important for you. Did they had any leak in the property, roof problems, plumbing problems, what major repairs they have done on the property, did they ask for permits, and things like that. Um, Once you receive it, if you have any extra questions about it, just let me know, and I will ask those questions to the seller agent to get answer for you. And again, once you receive this, you have 5 days to review it. If there is something that you decide you don't like, then you can cancel within 5 days of receiving this document. And it has to be something really major. Let's say the seller used to have a pool and they covered it up. And they got permits and everything, but they covered it up. And one of the things you want to do is do a pool. Well, now it's gonna cost you so much money, much more money that it will cost you, because there was already a pool. It means now you have to redo everything, and it's gonna be extra money to break into the concrete that is already there. So that can be a reason for you to cancel if something like this happens and we didn't know about it until it was disclosed by the seller. During your home inspection, I want you to contact your your insurance agent and get a quote on how much the insurance is going to cost on the property. On section 4B, line 157 to 161, all that is saying is also that the seller is going to provide us what is called an insurance claim history from the last 5 years that they have owned the property. If they have owned it more than 5 years, but if they have owned it less than 5 years, then they would just give you a report for how long they have owned the property. So let's say, and that's important information for you, because if they did a big insurance claim on the property, it can affect to you the insurance on the house, and it will affect you in the matter that it will cost you more money to insure the property that if those big claims were not done. Sometimes they have small claims, that's not a concern. Most of the times they don't have insurance claims, or having claims that happens a long time ago. But that's another report that the seller has to give us during those days. Now, sometimes we'll come across properties that they will say the seller is not going to give a property disclosure, or it's not going to be an insurance claim history. If you agree to that, then this part over here will not apply. Section 4C to 4D, 4C, line 162 to 166. It really applies only if you were not an American citizen or don't have the proper documentation to be in the country. So this doesn't really apply to you. Line 167 to 182, these lines only really apply if the house is built before 1978 It's just saying that the seller shall give you a disclosure. There is a form that we use that is called lead-based paint, letting you know if they know anything about lead or anything like that. If the house was built after 1978, then this section right here doesn't apply. And then we would just sign here. You do have 10 days to conduct a lead-based paint test if you want to. If you would like to do a lead-based paint test, you need to let me know, because sometimes those can take a little longer. Those are done by a different company than your home inspector. Changes during escrow. Again, it is important that any changes done during escrow, we need to let the seller know. If Then we're gonna go into the warranties. That will be the contract is stating that you are buying the house as is. The seller is not required to do any repairs. And everything that is working the day that you look at the property has to be working the day you close. That is why it's so important that you do a home inspection. Sometimes they have systems that are not working. And the most common I see are the water treatment. Most of the times the seller is not even using it. Doesn't have to be working when you are closing if it wasn't working before. That's an example. Now, if doesn't mean that if the air conditioning was working and by the time we do our walkthrough before closing, the air conditioner is not working, then the seller is responsible to repair that air conditioning. But what it's saying is that the seller doesn't have to do repairs on things that are not currently working when you put an offer on the property. Now, there are warranties that can survive closing, and that will be of something that the seller was aware of and didn't disclose, or any construction that he did by a professional. One example will be, let's say the seller knew there was a crack in the bathroom and now is creating issues for you when you move in. The seller didn't disclose it. It didn't come out on the home inspection for whatever reason, but it's something the seller was aware. Now, these kind of things can be a little difficult because you need to be able to prove all of that, but it's in the contract, and it's been cases where, um, you know, buyers are able to sue the seller and the seller has to remediate that. Line 207 to 212 is just saying that you are giving the seller all the information that they need to know, um, for you for them to know about you and being able to close. And if there is anything else that can prevent you from closing, then we have to disclose it. We always put there none, because unless you have a contingency, there is really nothing that can prevent you from closing. If you are with a loan officer that has collect all your paperwork, which is really the main thing. Now we're going to talk about the inspection period. I have another video that I did on YouTube, and I will send you the links where it explains it a little more in detail. But you, in the contract, have 10 days to do a home inspection. Because of the way the market it is, most of the times I'm using 3 days of a home inspection. Now, I have it here because it's a template I use, but I always ask you what you are comfortable doing. If you want to do more days, you can do more days. You are competing right now on this market with buyers that are even waiving their buy their home inspection. If that's something you're comfortable doing, and if that's something you want to do, I will put it on the contract. I don't recommend it that you do not do a home inspection because you don't know what are you going to buy. And also, if you are buying, you have a home warranty, which we're going to go over later. They're going to ask you for the home inspection, and if you don't have one, they might or might not do the repairs. Your home inspection is not just the inspection of the physical property, but it's other things that are important for you. If it's important for you to know if there is a sex offender, if it's important for you to know if somebody died in the house. Here in Arizona, the seller is not required to say if somebody committed suicide in the property. And if that is important for you, then maybe it's something you want to know. I always say, talk to the neighbors. They will be more than happy to tell you, about the homeowners, the neighborhood. I would say drive over the weekend, see if somebody likes to have loud music or too many cars or something that might bother you. Um, and I will say in this market, because we don't have a lot of time to do a home inspection and we're not getting quickly response from the sellers, do it while we are waiting for a response. Those things that you can do. I will send you a link to what is called a buyer advisor. It has a lot of resources for you to find out important information that is for you. I can only give you examples. I cannot tell you exactly what to look for because everybody is different. There is people that um, things that are important for them are not important for others. For example, I had a client. They actually bought a house where somebody died in the house. It really didn't bother them. But then I had another buyer a few years back, and she found out that somebody died in the property after she bought the house. And she just couldn't live in the house anymore. That was important for her. And that's why I cannot address enough to not feel embarrassed to knock in somebody else's home, a neighbor, and ask questions. They will be more than happy to tell you more about it. People like to share things. And if not, then you will know maybe you will have a mean neighbor. I don't know. It's important. This is going to be your house. It's a big investment. Once you bought the house is yours. You cannot give it back. So anything that is important for you, do your research. And if you don't know where to find it, I'll give you the link for the buyer advisory. You can always ask me. And I do not know everything, but I will try to find out where you can find those answers. The square footage of the house, I want you to understand that all the information that you see on the MLS is not always accurate. It's So if you want to verify the square footage, you need to do so during the inspection period. I do recommend that when you send a home inspector, you also do a termite inspection. Altogether, depending on the size of the property, can cost you between $350 to $400 on a home that is 1,500 or less. Any house more than that, you can expect from $400 to $500. If there is a pool, I recommend you get a pool inspection separated from your home inspection. The home inspector is not doesn't specialize on pools or air conditioning. I will send you a link where I talk about that more in detail. If the property is in a flood insurance and in a flooding zone, then you will be required to have flood insurance. Your loan officer is the one who is gonna run a report on that and then determine if the house is in a flooding zone. I do have a way to look and see if the house is in a flooding area, but my website is not 100% accurate. So we are going to rely on what the loan officer is going to find. I mentioned this to you before. If you once you are under contract during your home inspection, please contact your insurance agent. If you don't have an insurance agent, I really recommend you have one instead of just calling a 1-800 number. Um, Once you get under contract, I will send you the contact information of a friend of mine that I have that does insurance. She's an insurance broker, and she can help you with that and bundle your cars and everything, so you can get a discount and a benefit of having all together in under one insurance. Most of the properties are in sewer system, unless it's disclosed that it's not, and maybe it's in a septic, but very rarely in the houses that you're looking for, unless you decide to go for the big lots, then those more likely will be on a septic system. But that's also important for you to know um, during your inspection. I do recommend that besides your home inspection, you do a plumbing inspection. There is a company that runs a camera on the property. And I am going to say this because, especially if the house is older. I recently had a home buyer. They did a home inspection, everything was fine. And within a week that they moved, something was wrong with the plumbing. This was a 1970 home, and it flooded the kitchen. So thanks God they had a home warranty. They went with the home insurance agent that I recommended. The agent was really nice. He went to the house and pretty much helped my clients to do all those claims. It was a hassle and it was not pleasant, but they were able to take care of that. But you don't have to go through that. If you It's expensive, it's not cheap. It's about $200 investment that you're gonna do for having somebody and run a camera on the plumbing. You don't have to do it. I do recommend it. If I was buying a house, I would definitely do it. Um, but is an option. I do recommend it. Section 247 to 251 is just saying that there are regulations here in Arizona when you are owning a pool, and that is important for you to know this. Um, Seller doesn't have the responsibility to bring that for you, but even if the house doesn't have a pool, the language is there. Now, section 252 to 59 is in capital bolding letters. It's basically saying it is your responsibility to do your due diligence on the findings you want to know about the property you are buying. You cannot expect me to do the home inspection for you, or try to blame the brokers or myself if something happens after you close the property and you feel like it was my obligations to I'll let you know about that or tell you to investigate that. Again, I cannot do that because it put me in a liability position, and because that's not my expertise. What is important for me might not be important for you. So anything that is important for you, do that investigation during your home inspection. 3 days is not a whole lot, and that's why there is a lot that you can start doing, even if your home, your offer doesn't get accepted. But what if it gets accepted and there are things that you couldn't know, and you know after the fact if that was important for you, like having somebody die on the property, or sex offender, or I don't know what else will be important for you, having lousy neighbors. If you have, once you have finished your home inspection, or we are on day 3 or we're on day 10, whatever you are comfortable doing, your home inspection time frame, then we need to send a document to the seller that says, these are the items that we would like for you to repair or address. Um, I will send you another link to another video where my recommendations are on what is reasonable to ask the seller. Now, in this market, um, I'm seeing a lot of buyers that, again, they're waiving their home inspection. And when you are one asking for inspection period, a way to make your offer attractive is putting in writing that you would not be asking for any repairs. But again, this is language that basically is, it's a contract. And if you're not comfortable doing that, you don't have to do it. But sometimes that's another negotiation thing that we can do, where yes, you're doing a home inspection because you want to know what you're buying, but you are letting the seller know, I'm not going to ask for any repairs. At that point, if you find something and we already said no, we're not going to ask for repairs, and it's something that you know you cannot financially carry, to have over your shoulders, or the house is no longer appealing to you, then you can cancel the contract and get your earnest money back. This part over here, let's say you ask for items to be repaired, the seller has until 5 days before closing to do those repairs. If for some reason we go 5 days and those repairs have not been done, then we can issue a cure notice to the seller. Now the seller will be on breach of contract, and we were over the cure notice at the very beginning. But again, I can always explain it again. I don't expect you to remember everything I'm telling you in this video. It is a lot to process, it's a lot of information. It's a legal contract and it's a legal document. This section over here gives you the option to buy a home warranty. That expense is not included on your closing costs. And the home warranty can cost about between 600, 700 if it has a pool. It's really up to you if you want to buy a home warranty or no. It's not for everybody. A home warranty will only repair things until they can no longer repair it. Every time you call them, they will charge you $75. But let's say the water heater, they repair it and they come back again, they repair it, and now they have to replace it. They will replace that for you. A water heater probably costs around $900, $1,000. Now you pay, let's say, $600 for the home warranty and $150 on that person coming into the house. That pretty much pays for the water heater. But what about the air conditioning? Some home warranties will replace it. Some warranties will just give you a credit for a part of the cost. you will have, I'll give you a list of home warranties. You can call the rep or the company and ask questions and decide if that is for you. There are homeowners that say, no, I'm very handy, I can do those repairs. But then I have others that they're not handy, so it's convenient for them to have it. So it all depends on your situation. For example, I had a single mom, and for her, it makes sense to buy the home warranty. And when she bought the house, 3 days later, um, the air conditioning wasn't working. So she called the home warranty. They came and repaired for her. Well, for her, it worked. For others, it doesn't make sense because they are paying all this money when they have a friend, a family member, the husband, or one of them is handy and they know how to do all these things. So they have a friend on the air conditioning business or a family member, things like that. So that's a personal decision you're going to have to do. So line 938 to 304 is just saying before closing, normally 3 days before closing or 5 days before closing, we're going to go into the house to make sure everything is the same way that it was when you saw it last. Normally, that is when you did your home inspection. And if there is any repairs that the seller said they were going to do, this is the time where you need to make sure and ensure those repairs have done. If there is any repairs on areas that you will not be able to see, I always recommend to have the home inspector to come back to the property. They do charge a trip fee. But let's say you ask the seller to put some roof tiles. Well, you're not going to get on a ladder and look at it, right? We need to have somebody to verify that. Again, you have to do it. I do recommend it. If for some reason the seller has not done those repairs, then we need to do a cure notice and let him know. The seller has a responsibility to have the utilities on the property and give us access um, for our walkthrough with a reasonable notice. That's the responsibility. And then the next one doesn't apply to you. This is just for people that are foreign, again, that are not American citizen and don't have the necessary paperwork to be legally in the country. Remedies. So we talked about the cure notice before, and it's a breach of contract. Now, who's going to decide if really where the earnest money is going to go? Title company is. Title company is a neutral party. They make sure that everybody is in compliance with the contract. So when somebody is unhappy and issues a cure notice, and by the way, it's not something that happens often, but sometimes it's necessary. Then if there is a dispute, the title company will look at it and say, no, the buyer is entitled, according to the contract, the buyer is entitled to the earnest money, or the seller is entitled to the earnest money, whatever the case is. If you're not happy with an answer, then the alternative dispute will be with the Arizona Association or with the Arizona Department of Real Estate. They will look at the case. You will have to go to the real estate department and submit that, and then they will make a decision. If you're not happy with a decision, then you will need to hire an attorney, and you will be responsible for any legal expenses that will be coming from doing any of this process. This section over here is that when we put language that we want to be in the contract, for example, that you are waiving, if you decide to waive your home inspection period, that's something I will put in here. Or a lot of the strategies I'm using right now is that if you are comfortable, your earnest money will be not refundable after 16 days, because by then we will have the appraisal done, and we should be good to go. Everything should be ready for your loan to close. Line 390 to 393 is only saying that if for some reason something happened to the property as an act of God, it got on fire or it flooded or somebody came and vandalized the property and the damages are more than 10% of what the purchase price is, the seller has the option to say, I'm sorry, I'm not going to do any remediation on this property. Let's cancel this contract and move on with our lives. Then you get your earnest money back, but the seller has the right to do it. Or the seller can say, you know what, I'm gonna bring the property to where it was. Let's proceed with this. But you also have the right to say, well, you know what, I don't want to buy it anymore. And your earnest money will get back to you. Line 394, it says that the buyer and seller give permission to advise the public of the public of this contract. Now, it's not necessarily implying that this whole contract is going to be online and everybody can see your signature, your name. No, what it's saying is that we're going to put the house pending, or somebody might ask, oh, yes, the house is under contract. Arizona law, that means the contract is completely done within the Arizona law and in the state of Arizona. Time is of the essence, so it's important that everything is done within the time that is specifically on the contract. Section 398 to 403 is saying that the seller is responsible for paying compensation for my compensation as your realtor. So the seller paid for my fees, you do not pay me. Anything that is sent as an email, fax, we don't use fax anymore, but it's still, the language is still there, is considered an original and part of the contract. Days are calendar days. They're not business days unless it's specifically saying calendar days in the contract. So all the days are referred as calendar days. So if you get under contract on a Friday and you have a 3-day home inspection, Saturday and Sunday counts, or if it's 4th of July, it counts unless we specifically say something in the contract different. Days are begin at 12 a.m. and finish at 11:59 p.m. That means that you have time until 11:59 p.m. to be in compliance with something if you're having a cure notice per se. So the entire agreement, everything should be in writing. We can never take a verbal as a commitment from anybody. I have had times when I will have a call and the listing agent will say, the seller is going to accept your offer. I normally will not even call you because I know better until I get that offer send it, because a lot of times sellers change their mind and they ended up not selling the offer, or maybe another offer came in the meantime and they ended up not signing the contract, and I don't want you to be excited. So if there is anything that needs to be done and we want to make sure it happens, everything has to be in writing and signed by everybody. The seller has the right to receive other offers if they want to, but they cannot accept other offers. They can just have them as a backup. Cancellation of the contract if at some point any of the parties wants to exercise the right to cancel the program, the contract, they can do so. We need to let the title company know. And again, everything in compliance with the contract, if it's within your home inspection, when you have the seller property disclosure, insurance history, and things like that. Section 428 to 433 is just stating that the broker, myself, cannot provide with financial, legal, or tax advice, that you will not try to sue us because any of these, if anything on the findings of your home inspection you were not happy about it, is really your responsibility. If there is any legal advice you need, I can provide you with a real estate attorney. Tax advice, you can contact the person that prepare your taxes, or I can give you a contact information of somebody that you can consult with. Um, And then this line over here, normally the line 435 to 439, that's when we are saying when your offer expires. In this market, I'm giving 4 days to the seller to give us an answer, because a lot of times they take time, or they put the house on the market and we can only see it on a weekend, and they're not going to make a decision until Tuesday. And by then, 4 days pass by. So that's what is going to be in there. 440 to 442, it says that this contract contains 10 pages to make sure that you receive all the pages and all the addendum that might be included with the offer. By law, I am required to give you a copy of all the paperwork you sign. When we do things electronically, you automatically get a copy of it. So make sure you make a folder on your computer and you save it. Even though you automatically have that, I will probably more likely send you an email with a copy of it. And this is the last page, my friends. I know this is very boring. I don't want you to be anxious. I don't want you to be worried. I don't want you to be afraid. I am here for you, and I will always set the expectations for you. And I will always give you the worst case scenario. That doesn't mean it's going to happen. I just want you to be prepared. And if it doesn't happen, it will be a breeze. And you will be then, in no time, getting the keys of your house. So this last page, all it says is the information of myself, where I have my license, and my phone number that I will be representing you. And then the other part is going to say the seller's agent information, and the sellers is going to sign if they accept your offer, or if they send a counter offer. And that, my friends, is the end. There is one more form I'm going to go over with you. So this is the real estate agency disclosure and election. It's just saying my responsibilities from me to you. And it really basically, it says, I'm here to give you all the advice, but you will be making all the decisions that you are comfortable doing. I'm here to give you the resources. And if at any point might be a property that is listed with the broker I am in, then that will be considered a limited representation, because the broker is representing the seller and the buyer. And it's basically saying that the broker is working on behalf of the seller. It's also disclosing in here that the seller is not required here in Arizona to give you any information if the property was the site of a natural death, suicide, homicide, or any crime classified as a felony, owned or occupied by a person exposed to HIV or diagnosed as having AIDS or any other disease not known to be transmitted through common occupancy of real estate, or if the property is located within the vicinity of a sex offender. This information is here in the contract and on this because it's important for you to understand what the seller is not obligated to disclose. And if any of this is important for you, please do your research. You can contact the police department. There is a website for registered sex offenders that will be on your buyer advisory. I will send you the link for that. And it's a lot, but you know what? I don't expect you to know everything. I don't expect you to remember everything. Like I mentioned before, I am here to help you, and thank you for the opportunity to help you with the purchase of your home. I am looking forward to go house hunting with you. Bye bye.